I want to thank DSF so much for inviting me to be the last speaker today. So my name is Kathryn Benson and I'm a Senior Human Resources Consultant with HR Options, and we're a total human resources outsourcing provider. And today I'm going to be discussing managing employee medical leaves of absence. So just to review what I'm going to talk about, I'm going to remind everyone a little bit about the human rights protections. Alexandra has already done a great job of going over the case law, so it'll be a very brief slide. And then I'm going to look specifically at some management tips on family medical leave, personal emergency leave, and we're going to discuss short-term disability and long-term disability. So a quick reminder on whenever an employee takes a job-protected leave under the Employment Standards Act, or the ESA, they of course have the right to be reinstated to the job, and that means to the same or the similar job if their original job was eliminated while they were on leave. And keep in mind they're also eligible for the same pay, and if the pay was increased while they were on that job-protected leave, they're entitled to that increased pay. And of course they have the right to be free from penalty or discrimination from the employer for taking the leave. And they have the right to continue to participate in benefit plans. So pension plans, health and dental, group benefit plans. A little caveat there, if the employee on leave was contributing to the premium for the health and dental plan, they must continue to pay that premium into the plan in order to stay on that plan while they're on leave. So the first leave I'm going to look at today is family medical leave. So this is also known as compassionate care leave at the federal level or in other provinces. And to qualify, an employee can be full-time, part-time, contract. They could have started yesterday. There's no length of employment before they qualify. And they take the leave to care for a family member or someone they consider to be like family, which is important to note, who's at risk of dying in the next 26 weeks. And of course, they have to provide a doctor's certificate to you to prove that they are qualified to take the leave. And the entitlement is 8 weeks of unpaid job-protected leave under the ESA. So some management tips if an employee of yours is taking family medical leave is the leave doesn't have to be taken consecutively. It can be taken in chunks. And if the family member continues to be at risk of dying after the 26 weeks, they can apply for more time. And the 8 weeks can be shared among others. So for example, if a brother and sister are taking a leave to care for a dying parent, the brother and sister can either take 4 weeks of the unpaid leave at the same time, or the sister can take 4 weeks, go back to work, and then the brother can take the other 4 weeks. They can't take a total of 16 weeks to care for that one parent. And the employee, of course, has to provide, along with the medical certificate that they provide you, they have to provide you written notice of their intention to take the leave. However, from a management point, keep in mind that if someone is going on a leave to care for a dying family member, they're obviously going through a lot of turmoil in their life. If they don't provide that documentation to you before the leave begins, that doesn't negate their right to take the leave. They can still take the leave, give them a reasonable amount of time to provide you the medical certificate and the notice that they're taking the leave. Because the leave is unpaid, they can apply through Service Canada with their record of employment for employment insurance benefits called compassionate care. The next leave I wanted to talk about was personal emergency leave, which falls under Ontario's ESA. And I chose this one because a lot of times it's confused with family medical leave. And the personal emergency leave is a separate leave under the Employment Standards Act that provides employees 10 unpaid job-protected days to care for an illness or injury for themselves or a family member. And it's important to note, again, from a management point here, is that if an employee starts in October, they still have a right to those full 10 unpaid days till the end of the year. So as an HR department, you can't prorate those days. And unlike family medical leave, the list of family members is more restrictive, and you can find those in the Employment Standards Act. And the employer has to employ 50 or more employees for an employee to take the leave. What's important here is that those 50 employees don't have to be just in Ontario. It can be across Canada, it can be internationally, and also part-time and temporary employees will count as a full employee count when you're looking at your total employee count. My next slide is, I wanted to delve a little bit deeper into an urgent matter. So you can take the leave for an injury or illness for yourself or a family member, or an urgent matter. And I find that this definition of urgent matter is what gets under the skin of most employers or HR departments the most, because it's very vague. What does it mean? So under the Act, it is defined as an event that is unplanned or out of the employee's control and raises the possibility of serious negative consequences, including emotional harm, if not responded to. So what does that mean? The ESA does set out some specific examples, and I'll give some to you to help you define what personal emergency urgent matter is. So let's say an employee has a planned surgery to care for an illness or injury that they had or a family member had. That does qualify under the personal emergency leave. Also, what qualifies is if their babysitter calls in and they make reasonable efforts and cannot reasonably find anyone to look after their child, that actually does qualify as an urgent matter. I give a few more examples on the slide, but I also wanted to say that we've occasionally been asked if an employee does something very silly to themselves. Let's say they try, I don't know, kiteboarding at their cottage on the weekend and they injure themselves. We have been asked, does that count? They injured themselves. Is that a job protected leave? And the answer is yes. It doesn't matter if someone does something silly, they still are going to be eligible for personal emergency leave if all the other qualifications exist. What doesn't qualify is, and these hopefully are obvious, if an employee wants to go to their daughter's track meet or their sister's wedding. And also, I talked about surgeries. It can't be cosmetic surgeries. So obviously your liposuction appointment is not going to count as an urgent matter under the personal emergency leave. So the next important note under personal emergency leave is how do you integrate your employer's sick day policies with the personal emergency leave legislation. And the simple rule of thumb is that if your employment agreement or employment contract provides a greater right, then that employment contract is going to apply. But what's interesting here is that the Ministry of Labour is not going to jump in and help you determine what your policy should be if there is a disagreement between what your sick day policy is and what the employee thinks they should get under the personal emergency leave. So for example, let's say you provide 3 paid bereavement days and 3 paid personal emergency days to the employee, and the employee has a family member that passes away. That's an urgent matter. So they take those 6 paid days that you've provided, and then you can say to that employee, you get another 4 unpaid job protected leave days under the Personal Emergency Leave Act. So you can take a total of 10 days. The employee might come back to you and say, wait a second, it wasn't very clear in my employment agreement how many paid days I get. So I think I should get those 6 paid days plus still get my 10 unpaid job protected personal emergency days. Don't bother calling the Ministry of Labour. They will not comment on that. So that's going to be up to you to work with the employee and figure out what's reasonable and fair, and of course apply whatever you come up with consistently across the rest of your organization. So there are some new leaves coming down under the Employment Standards Act that will come into effect in a few weeks on October 29th. And one is the family caregiver leave. So this kind of complements the family medical leave in that now employees can actually take time to care for a family member who's not at risk of dying. So they can get 8 weeks of unpaid leave. And there's also critically ill child care leave. So, and the difference here is the employee must be employed for 6 months to be eligible to take this leave with you, and they can get up to 37 weeks of unpaid leave. Now hopefully none of these leaves ever apply to anyone in your organization, but especially this last leave that's coming into under the Employment Standards Act, and that's a crime-related death and child disappearance leave. So again, the employee will have to be working for you for 6 months to qualify, but they can get up to a year of unpaid leave. And if, because of their disappearance, the authorities think that the child has actually passed away, they can get up to 104 weeks of unpaid leave. So again, hopefully that never happens in any of your workplaces. So my next topic is short-term disability and how some just helpful tips on how to handle short-term disability leaves. And I find in my experience that there's 2 very common scenarios that come up when employees take short-term disability leave. So one is the employee comes and they're very forthright and they say, you know what, I have a surgery planned and I'm going to have to be off for a few weeks or a couple of months or whatever it is, and you can work with them through that process. Unfortunately, I'm sure all of us have experienced my next scenario is that an employee just keeps calling in sick. Day after day, they're calling in sick, so you get to the point where you're thinking, okay, I've got to take some more action here. So my first recommendation is, of course, to look at your paid time off policy. So do you provide paid sick days? If you do, how many do you provide, and has that employee used them all? Make sure the employee knows, listen, you've used up all your paid sick days, your time moving forward is going to be unpaid. So that's the obvious place to start. Also, look to see if that employee is covered under your group benefit plan if you have one. And if they are, do you have a short-term disability plan that they're covered under? If they were hospitalized or in an accident, that short-term disability plan will kick in right away so they can get some money while they're on off leave. And if they weren't in an accident or hospitalized, then usually they have to wait around 8 days to start collecting their short-term disability benefit. So look at those parts of your benefit program. And of course, you're going to want to obtain medical documentation. So first, make sure the employee's under the care of a qualified doctor. And I say qualified doctor on this slide only because if you do have a short-term disability plan, the insurance carrier might be a little sticky about who the doctor is. I've never seen a carrier reject a doctor, but in case you're concerned, a good step would be to get the doctor's name and check with your carrier that all is okay. Also, you're going to want to use a medical request form. And by that I mean, don't just say to the employee, we need a doctor's note saying that you're ill and maybe when you're going to come back. That's not good enough. What you should do is use a form that you've created with specific questions that you need to know as the employer. And I have provided an example of a medical request form in the pamphlet that you received from DSF this morning. I think it's the last insert on the right-hand side. So that medical request form is going to ask the obvious questions, you know, are they ill, when are they expected back, if the doctor doesn't know when's their next appointment, when you might be able to tell us when they're coming back. And very importantly, it's going to ask questions about accommodation, so your return to work process. If they are coming back, what job conditions do you have to alter to accommodate them? Again, Alexandra touched on how important it is to accommodate an employee who's off because they are ill. It's really easy as an HR manager or a manager to be so focused on getting that doctor's note to prove that the employee is sick that you forget that you also need vital information from that doctor when they're coming back from leave to make sure they've got the clearance to come back to work, and again, what job conditions you might need to alter. And please attach a job description to that medical request form, because without the job description, the doctor is not going to be able to really give you an educated information on the accommodations that might need to happen when they come back to work. Also, if the employee is under a short-term disability plan, and even if they're not, stay in touch with the employee and make sure they know what the deadlines are for getting those forms in. So under a disability plan, they're going to have the employee is going to be in charge of getting a physician statement filled out and an employee statement filled out and submitted to the insurance carrier. And of course, you as the employer will fill out a form too to submit to the insurance carrier. And keep confidentiality top of mind. Keep in touch with the employee and make sure they know the deadlines of the forms, but also that the physician and the employee statement should not be mailed back to you. That's information you do not need to know. You don't need to know diagnostic information. You only need to know specific return to work, job-related information. So make sure they know where to mail it to your insurance carrier. And again, I stress, give them the deadlines, because if they're off ill, and we've experienced this a lot, employees, they're not thinking clearly. It's quite overwhelming for them. So as an HR person, keep in touch with them so they know what's going on. If their physician is late in the form, then help them out. You know, talk to them about speaking with the physician, not being shy to speak to the physician to get it in. And also pay for the medical request form that you, separate from the short-term disability form, that the paperwork you're going to have to do for your STD plan. If you're getting the medical request form filled out, which I think you should always, make sure you offer to pay for that form so you can get it back. These doctors will always have a fee for filling it out. And my last point on this slide is to remain empathetic. And I put that on the slide because it's very easy to get into a defensive position as an employer and think, you know what, that employee, there's no way they're really sick. You know, they're on a performance improvement plan, or we were about to let them go. They're playing the system, they're not sick. And we've all been there where we've been suspicious. But don't let that overtake your management of the situation. Keep the doors of communication open. Keep talking to them. You don't want to hire a private investigator to follow them around. You don't want to check their Facebook page and find out that they've been on vacation in Mexico, because if they're on vacation in Mexico and you say to yourself, aha, I've caught them, they're not really sick, and you let them go, they're going to come back with you. They could come back at you with a wrongful dismissal case. What if their doctor told them they needed to get stress relief and recommended they go on vacation? What if they had a vitamin D deficiency and had to go to Mexico? You know, there could be reasons. I may be stretching, but there could be reasons. So do your due diligence when going through the process. If it ever does end up in a court case against you, you want to show that you've acted in good faith, you've understood the human rights, that they're off and they're protected by human rights, and that you've gone through the steps of accommodating them and helping them through their leave and helping them get back to work. Of course, I've talked a lot about if you have a short-term disability plan. If you don't have a short-term disability plan, which a lot of standard group benefit plans don't, then what you're going to want to do is issue the record of employment to the employee, and again, keep the doors of communication open with the employee. They're probably overwhelmed. They may have never applied for employment insurance, and they may think that there's a stigma attached to applying for employment insurance. So put their mind at ease and say, you know what, no, take your record of employment. Here's the online link to apply online at Service Canada. And there's going to be a 2-week waiting period where you don't get any payments, and then payments will kick in for a maximum of 15 weeks up to a maximum of 55% of salary, up to a maximum of $514 a week. So those little key factors are going to be key to putting that employee at ease and you helping them through their short-term disability leave. So this slide just kind of recaps everything I just talked about, and it's in your notes, so I won't go through it in detail. What if the employee's short-term disability leave turns into a long-term disability leave? So I just have a couple quick slides on this, and my rule of thumb here is, of course, check with your insurance carrier again. Are they covered under your group benefit plan for long-term disability? If they are, keep in touch with the insurance carrier. What's the elimination period? Meaning how long do they have to be totally disabled, meaning they can't work, before their LTD will kick in? It's usually around 119 days. Some insurance carriers will allow for a trial period where the employee can come back to work and maybe part-time to see if they're okay to work. And if they're not, it won't affect their elimination period. They can still apply for LTD on time. So check out those little aspects of your plan. Does that apply? And then all the tips that I gave under short-term disability apply in terms of making sure they know when to get the forms in, that the forms go directly to the insurance carrier that they're in charge of. All of those steps apply. Keep the doors of communication open. And my last slide just talks about, my second last slide is don't rely on the insurance carrier to give you medical information. So don't just sit back and say, oh, the insurance carrier will help let me know what's going on with this employee and when they'll be back. So they won't. They will give you certain information, but use that medical request form that I've provided in the folder and that I've talked about as many times as you need to get the information back that you need about accommodation and when they'll be back from work. And now my very last slide is that one of the most difficult things when someone's on long-term disability is determining when and if you can terminate them from, not just from employment, but from your health and dental plan. So if someone on disability is on your health and dental plan, they're probably using a lot of your prescription coverage, it's driving your experience ratings up. They may not be employed, they haven't been working for you for a long time. So a common question is, when can I just take them off my health and dental plan? And the answer to that is, unless you have a very clear statement in your employment agreement up front saying that